Hi, I'm Shannon Farrell with the OSU Department of Agricultural Economics, and in this portion of the Farm Transition video series, we're going to talk about some critical estate planning documents that everyone should consider as part of their estate plan. Now, this is not the traditional thing you may be thinking about, the wills and trusts. We're going to talk about those in another video, but we're going to talk about some of the other end-of-life or estate planning documents that everyone needs to at least think about. So, what we're going to talk about today are guardian nominations for minor children. So if you have children under the age of 18, who is going to take care of them in the case that both parents pass away? We're going to talk about beneficiary designations. In other words, ways that you can designate that certain kind of investment accounts can be transferred to someone else after your passing. We're going to talk about powers of attorney, and those can be broken into business powers and healthcare powers as well. Both of those are very important. And we'll talk about healthcare directives. Healthcare directives are things that direct your instructions for end-of-life care, for example. Now, obviously, we think that everybody should have a will as part of their estate planning, but that's a topic completely to itself, and we'll talk about that in another video. Other things that are really important for everyone to consider, at least as part of their estate plan, are trusts, and if that trust would be the right tool for them. For some people, yes. For some people, it may not be necessary. And also life insurance. Again, life insurance may be a really valuable tool for some people, but for other people, it may just not be needed. Now, the first thing we're going to talk about is what we call the guardian nomination for minor children. And what that is basically a document stating who you would nominate to be the guardian for your kids under the age of 18 until they reach that age. Now, it can be incorporated into your will, or it can be a separate document entirely. Many people do it within the context of a will, and if you have minor children, that just again underscores the importance of having that will. But you don't have to have a will. You can do this as a document that stands on its own. Now, this document is given a lot of respect by the court. Basically, unless it can be shown that the person that you've nominated wouldn't act in the best interest of the child, the court's going to go along in almost all cases with the nomination. So this is a really important tool for you to use. Now, considerations for you as you're going about creating the nomination for your minor kids is, number one, to discuss it in advance, both with you and your spouse and with the person that you're nominating. This can be a really big surprise if you don't tell the person that you're nominating that they've been nominated. That's a really important step. You need to talk to them about what your wishes would be for how you'd want your children to be raised, things that they might need for their care, and so on and so on. So obviously it's critical to discuss the nomination with the person that you're nominating. Now, it's also important that you may want to consider providing resources for the care of your children. And that, again, underscores the importance of estate planning, having a will, and those other sorts of documents in place. The guardian nomination standing by itself won't necessarily transfer any of your estate assets to the people that you've nominated. So if you want those people to have some of your resources to take care of your kids, you need to make sure that you integrate that into your estate plan. Now, you need to have those nominations accessible. What I mean is you may not want to put that into a safety deposit box, for example, where lots of people put their important documents. And the reason for that is that after you die, there's a great number of restrictions on who can access your safe deposit box, and it may not be accessible by the people you've nominated to be those guardians. So make sure that you talk to your attorney that's drafted your nomination and make sure you keep that in a place where it's accessible by the people that need it. Okay, next up, we have the beneficiary designation, and this is perhaps one of the easiest estate planning tools out there to use. And a beneficiary designation is simply a provision of a contract that you have, probably as part of some other investment contract, like your brokerage accounts, your investment funds through your workplace. But most of those sorts of instruments have a feature, a designation that says, who would you like to receive this asset, the investment account or whatever it is, when you pass away. Since you've got a separate contract that deals with how that asset is disposed of when you die, that doesn't have to go through probate. So again, the beneficiary designation is really inexpensive, really effective, a great estate planning tool. But so often, people don't think about their beneficiary designations or don't check up on them regularly. So what we're going to tell you to do is make sure that you go through all the investment programs that you've got and see if they have the beneficiary designation and if it is what you'd like it to be. So when you're working through your beneficiary designations, first off, again, make sure that's an available feature for whatever your investment is. Make sure that you stay on top of them. Let's say, for example, you started a job, made a beneficiary designation, perhaps to your parents, perhaps to your favorite charity, but then you got married. Did you go back and check on that beneficiary designation? Because now you might want that investment asset to go to a spouse rather than that charity or to your parents. So whenever something significant changes in life, make sure you go back and review those beneficiary designations. By the same token, anytime you change jobs and may have new investment accounts, make sure you update your beneficiary designations and see about the portability of those old designations that you've already made. Again, every time something big changes, make sure you go back and update those designations. Understand too that when you make a beneficiary designation, that's going to be binding. If you've designated that you want that asset to go to a spouse or to a child, that's where that asset's going to go. Do you want that asset to go there, or do you need that asset to serve some other role in your estate plan? You might want to designate that asset for the payment of any debts that you have remaining. Or you may want it to be part of a broader plan that's spread amongst many recipients. There's no right or wrong answer. What you just need to do is think through all those alternatives and make sure that the designation reflects truly where you want that asset to go. Okay? Now let's talk about the power of attorney. Power of attorney isn't so much of an estate planning tool, but it's a tool that can be very important if we've got a prolonged illness or if we've got a period of our life where we're just not capable of taking care of ourselves. Now, what a power of attorney is an authorization for some other person to act on our behalf. In the eyes of the law, the person that holds the power of attorney is us. They are indistinguishable from us in their legal power. And so it's a really powerful tool, but it's also a tool that we have to monitor very carefully. Now, if we're talking about someone taking care of us when we're incapacitated, it's crucial that we make this power of attorney what we call a durable power of attorney. An ordinary power of attorney goes away. It basically disappears when we become incapacitated. And the reason for that is because the law wants to make sure that you're capable of monitoring someone that you've given this power to, because it is so important. But if we make this a durable power of attorney, that means that even if we're incapacitated, the power of attorney remains viable. So if we want someone to be able to take care of us when we've got a debilitating illness, we need to make that power a durable power. Now, this power can be very broad. We can basically empower this person to take care of all of our business affairs or all of our healthcare affairs. Or we can be very specific. We can limit what things we want them to be able to do and what things we don't want them to be able to do. Now, our considerations as we go through the process of figuring out our power of attorney, first off, we need to make sure that it is durable if we want it to be able to work while we're incapacitated. And your attorney can help you come up with language to make sure that that power does last even while we're incapacitated. We also need to understand that anyone we've given our power of attorney has the power to act like they're us. So we need to make sure we supervise their use of that power and make sure nothing's been happening without our knowledge or our ability to fix it. We also need to understand that we can specify whether we want this power to be a business power or a healthcare power, or in some cases both. And again, when we talk about a business power of attorney, what we mean is someone can take care of our business affairs, paying bills, maybe selling property, receiving rents from properties, basically handling financial affairs. The healthcare power of attorney means we're empowering this person to act with our judgment, basically, as to what kind of healthcare procedures we have, what kind of care we receive. That's something that we can also deal with in the healthcare power, sorry, the healthcare power of attorney, but rather the Advanced Directive for Healthcare, or the Healthcare Proxy. And we'll talk about that later in this video. But make sure that if you have a healthcare power of attorney that you don't conflict those provisions with a healthcare directive or some other instrument. So let's talk about what a healthcare proxy might look like. When we're talking about a healthcare proxy, it's basically the same function as a healthcare power of attorney. The reason that we talk about it in slightly different terms is because a healthcare proxy may often be linked with another document like our Advanced Directive for Healthcare or Living Will. Okay? So the healthcare proxy, like we said, empowers someone else to make medical decisions for us. Now, when we have a proxy, sometimes people want to give all of their children a say. They don't want to treat a child, for example, if they've made a child a proxy, any different from the other kids. And what that results in is us having multiple proxies. That can be really problematic for physicians, though, because if there are multiple healthcare proxies, the physician has to contact all of them to get a decision. And that can be eating up time that may be really critical in an important medical situation. So it may be better to have one healthcare proxy rather than others, just for the sake of making decisions more quickly. When you've selected a healthcare proxy or a healthcare power of attorney, it's very important that you discuss with that person your values, your ideals, your beliefs with respect to healthcare, especially if it's a critical, life-threatening situation. You need to know that they understand and are willing to carry out what your values are without necessarily imposing their values on the decision. And on that same line, you need to make sure that your healthcare proxy is capable of carrying out the task. Your healthcare proxy may be called upon to make some really difficult decisions. And again, many times healthcare proxies are chosen either as spouses or as children. And you may have a spouse or child that loves you very much and just can't bear to be without you. But if you've asked that person to make some important and difficult end-of-life decisions for you, they may not be capable of doing that. So you need to make sure that you've selected a healthcare proxy that can actually carry out the task as you would want it to be done. Now, let's talk about a living will, which is different from a healthcare proxy. A living will basically states what kind of end-of-life care that we do or do not want, okay? Whether or not life-sustaining treatment should be given in certain kinds of circumstances. Most of the time, a living will is triggered when we have what we call a terminal condition. Terminal conditions, persistent unconsciousness, or an end-stage condition. Now, these all have their own unique legal definitions, and we need to talk about those for just 1 second. A terminal condition is regarded as being incurable, irreversible condition likely to result in death within 6 months. So that's probably what most people would get in their minds when they heard the term terminal condition. When we talk about someone who's persistently unconscious, what we mean is they have a condition that really doesn't show any signs of being reversible, in which thought and awareness of self and the environment are absent. In other words, the person basically doesn't have any connection with the outside world. And an end-stage condition is a little bit more complicated, but an end-stage condition basically means that the condition that the patient's in is irreversible and that any medical treatment would likely be ineffective. So those are the 3 situations in which we see living wills most often triggered. So, our considerations in creating our living will. First off, we can direct whether we want our life to be extended by life-sustaining treatment or not, in one of those 3 conditions like we just discussed. And life-sustaining treatment can have a number of aspects to it as well. If we're talking about resuscitation, if we're talking about respiratory support, if we're talking about food or hydration, those are all things that we can specify in our living will. We can talk about life-sustaining treatments, we can talk about nutrition, hydration, methods by which we'd want to have those delivered. For example, if we can't take food or water ourselves, do we want those to be administered by feeding tube? Or is that the step that we want to say we want to have those measures withdrawn from? Whenever you've got a living will, it's absolutely critical that that be kept somewhere where it's accessible, both by your family members or whoever your executor of your living will is, and by your physicians. Many times when you check into a physician's office, they may ask if you have a living will and if they can have a copy on file. If you know that there are certain physicians where you would be treated in some sort of situation where the living will might be invoked, it's really important that you have a copy of that will available for them. Again, living wills probably shouldn't go into your safe deposit box because those can be very difficult to access by the people that need them in the circumstances that they need them. And again, like we've talked about before, talk about your living will with your family. It's important that they understand what your wishes are. Now, a living will is a binding document, and physicians are legally bound to either uphold the provisions of your living will, or if they feel that they can't from their own belief standpoint, they're required to transfer you to a physician that will. But your family can complicate that process if they don't believe the same way that you do. So discuss this with your family, make sure they're on board with it. Now, we can combine these elements into an advanced directive for healthcare. An advanced directive often will involve your healthcare proxy, in other words, your healthcare power of attorney or the person that's empowered to make healthcare decisions for you, a living will, which we just talked about, and directions for organ donation. All 3 of those components can be bound up in what we kind of comprehensively call an advanced directive for healthcare. Now, if we're going to execute an advanced directive and unify all those pieces together, make sure we don't have conflicting provisions between that combined document and any other separate documents that we may have executed. It's important that you have one set of instructions and only one set of instructions so there's no opportunity for conflict. And just like we've been talking about in earlier segments, again, make sure this document is on file with your physician, readily accessible to whoever your proxy or your executor is, so that they can carry out those instructions and find them easily when they need to. So, in this video, we've talked about several estate and end-of-life planning documents that are really important for everyone to investigate. We talked about the guardian nomination for kids under the age of 18. We've talked about beneficiary designations on investment accounts. We've talked about powers of attorney, both business and healthcare. We've talked about healthcare directives, and those are kind of the big pieces. Now, there are other big pieces still out there. We haven't talked about wills, we haven't talked about trusts, and we haven't talked about life insurance, but those topics are going to be addressed in other videos. But in the meantime, if you want to review anything that we've talked about today, or if you'd like to access any of our other references or to download the Farm Transitions Workbook, all you have to do is go to agecon.okstate.edu/farm transitions, and all of those resources are there for you. I'm Shannon Farrell with the OSU Department of Ag Economics. Thank you for watching.